Okay, Rambam. We're doing business law. Let's get to business. Doing the laws of Mechira, chapter 7, the laws of sales and acquisitions. What's a sale? How do you make a sale? When is the sale complete that parties can't go back on the agreement, right? So on and so forth. So whenever a person pays money, but does not perform a shicha on the product. So biblically, to acquire something, all you have to do is pay for it, right? Rabbinically, the rabbi said that's not sufficient. You have to pick up the product. You paid for this. That's good biblically, but not enough rabbinically. You have to take possession of the product, pick it up, or if it's like an animal and you can't pick it, so you got to draw it, meshicha, right? On the produce. Let's say you're buying, a whole pallet of apples. Well, you're not going to pick it up. So you got to move it, right? Although the purchaser does not acquire the movable property, right? In other words, you paid for it, but you didn't draw it, you didn't move it, right? So you didn't acquire the movable property as we've explained, right? Now, why didn't you acquire it? If you can let in anybody and everybody, thank you. Why didn't you acquire it? Biblically, you have, because you paid for it, right? But the rabbi said, no, it's not enough. And the reason why the rabbis did, because if a person paid for something and it was left in the seller's domain, the seller's not going to be so careful with it if something happens. So therefore, you need to make an act of acquisition, lifting it up, if it's a lift, or in the case of like a pallet of produce, you got to move it, right? So legally, you could retract even though you paid, right? Whether the purchaser or the seller. This is considered not to conduct himself in a Jewish manner, but that's not appropriate that you would do that. And this person who retracts, because remember, you paid for it. So biblically, it's a sale. Just rabbinically, it's not. But it's not proper conduct that if you paid the money now that you're going to retract and say, oh, you know what, I don't want to buy or I don't want to sell, right? And the person is liable to receive an adjuration referred to as a mishapara. We'll see what that means. Adjuration, it's a curse. You're going to get a curse. Even if the purchaser only made a deposit. If either of the parties involved retracts, the party is eligible to receive a adjuration referred to as mishapara. Ooh. When does receiving an adjuration referred to as mishapara involve? He is cursed in court and told, may he who exacted retribution from the generation of the flood, the generation of the dispersed, the inhabitants of Sodom and Gomorrah, the Egyptians who drowned in the sea, exact retribution from a person who does not keep his word, because you didn't keep your word. You paid for it. Again, either side could still retract, right? Because it's not a complete contraction rabbinically, but biblically it is. So meaning you shouldn't retract. You're allowed to, but then you're going to get this curse. After the curse is administered, the seller should return the money, right? The product wasn't taken yet. Remember, because once you move the product, you paid and you move the product, then you can't retract. Then you can't, there's no retraction because that's a full sale. Well, halachically, I made the distinction there just so you can appreciate what's going on. But halachically is the point, right? Halachically is a complete sale. Okay. Number 3. Following laws apply when a purchaser pays either completely or partially for movable property that he desires to purchase and then retracts. And the seller tells him, come and collect your money. All right. So he's retracted, right? He's put down a down payment or maybe paid for the whole thing, right? And now the purchaser is retracting. So the seller, who's got part of the money or all of the money, so okay, come and collect your money. The money is considered to be an entrusted object. If it is stolen or lost, the seller is not responsible for it. He's not responsible for it if something happens to it. It's an entrusted object, like I would imagine means like a non-paid guardian, right? And a non-paid guardian is not responsible for stolen or lost. If you're a paid guardian, right, then you would be responsible for if it was stolen or lost. But he's a non-paid guardian, right? Because, hey, the guy retracted, right? I've got Ruvain's money in my hand, but he said, okay, deal's off. So, but I got the money. So, so come get your money. I'm not responsible for it now if it's stolen or lost. Obviously, if I'm negligent, that's a different story, right? That's a different story. If, however, the seller retracts, now it's the other way around, right? The money is considered to be held within his domain. He's responsible for even though he tells the purchaser to come and collect your money. Now it's the opposite. Let's say I retract. I'm the seller. I've got the money. So now I'm considered a guardian, like it's a paid guardian, right? And therefore I am responsible for this money because I'm the one who retracted. Even if I told you come and get your money, right? This applies until he receives an adjuration mishapara and tells the purchaser afterwards, come and collect your money. Yeah, once he gets the curse, that's a different story. Why is that? Nothing more the seller can do. The purchaser is responsible to collect his money. Okay. Number 4. When a person is owed a debt by a colleague, and tells him, sell me this jug, right? Someone owes me money. So I tell the guy, sell me the jug of wine for the debt that you owe me. And the seller agrees. It is considered as if the purchaser paid the money at that time. If either party retracts, he's liable to receive a adjuration, mishapara, right? Even though it wasn't money that was given specifically, but we consider it as if you gave the money right now, even though the money was owed money. But it says it because it was owed money, now is being paid for this thing. Moreover, if he sold him landed property in exchange for a debt, neither party is allowed to retract. This applies even if the money was given as a loan, is no longer in the seller's possession at the time of the sale. How come? When it's movable property, you can retract, right? Landed property, you can't. How come? Hmm? What? Oh, because the landed property is finalized by the payment of money because you can't pick it up and you can't move it. Exactly. Remember, the moving of the picking up, right? Actually the preferred way is called hagbah, lifting it up, the object. Lifting it, hagbah, that's the preferred. That's only with something that's right. But if it's a pallet of produce, you can't do that. So you have to draw it, or like an animal that you purchase. So you're not going to lift it up, cow. You're going to move it, right? So that's a rabbinic law that only applies to metaltalin, to movable property, right? But not to land. There is no, right? There was no rabbinic law for that. So then the purchase is final. Of, giving the money. Halacha number 5. When a person purchases landed property, servants or other movable property from a colleague, a price is agreed upon. The purchaser leaves collateral in place of the money. The transaction is not completed. Either the two can retract. He is not liable to receive an adjuration mishapara. Why? Because I didn't put down money for the sale, right? I just put down collateral that I will put down money, even though the collateral is worth something, but I didn't give money, as it were, for a sale. It's only collateral. So then you can both retract. Because biblically, if I'm biblically, I want to buy this, and I'm giving you a pen as collateral. If I'm giving you a pen as partial payment, right? So then it's a partial payment, and therefore, biblically, it's a sale. It's not a sale until I pick it up completely, right? Not a complete sale, right? So you could retract. You will get the mishapara if you retract, but you could retract. But over here, we're talking about I gave a pen as collateral. So it's not payment for this. So then there was really no transaction here. Collateral is not a transaction. It's just it's like, in a sense, giving my commitment. It's a commitment, obviously, by giving collateral, but it's not transactional. Giving money, partial payment, that's transactional. That's called a purchase. Rabbi said that you need more than that, fine, but biblically that's called a purchase, and therefore you should not retract from it. But this is collateral, so therefore you can both retract, and there's no bishapara. Amazing, like. Following rules apply when a verbal agreement alone was concluded with regard to a sale. Verbal agreement. A price was established. The purchaser made a mark on the article so that they will have a sign that it is his. Even the purchaser did not pay any money at all. So here's verbal agreement. If either of the parties retract after the purchaser made a mark, and the important point over here is he made a mark. He's liable to receive a adjuration mishapara. Whoa. Why? There's nothing transactional that happened here. Huh?
Stands instead of money exchange. So this is as good as a complete transaction. That's what it means.
So making the mark, that's the point over here. It's as if you already paid for the article you desired. Interesting. I like so that. That's huh?
In the fact, it's a sign of the transaction is completed.
Yeah, exactly. Right. That's interesting.
Yeah, because the mark distinguishes this from other items. This item.
Yeah, but when I gave, but in the previous halacha, when I gave collateral, see, well, look at the nuance over here. Look at the nuance. I gave this as collateral, right? But that didn't make this set aside for me. That was only on my part, right? But on the seller's part, right, that it was now being moved from his domain, right, to the purchaser's domain, he needs to make that mark. Making that mark, he did something that there's some form of transference over here in that mark, and therefore, again, you can retract, but you'll get a mishapara.
for instance, the bank, when you offer loans, a loan just offering collateral doesn't make the loan complete. Because you can get the loan without a transaction, without collateral. But merely having collateral doesn't mean you will get the loan.
Right,
So I understand that concept.
right. Moreover, if it is accepted local business custom that making a mark constitutes a binding act of contract, by making the mark, the purchaser completes the transaction. Neither can retract, and the purchaser is liable to pay for the price agreed to. Right. In other words, that's a local custom. Is that let's say you go to the butcher. A good example of the butcher, right? He cut up. You didn't pay. He cut up the meat for you, and he put it in the package, and he put your name on it. Right? You didn't do any. You didn't pay for it, right? So there's nothing transactional. But if that's the custom, then when you go to the butcher and he puts your name on it, right, then that's called the transaction. In other words, you can't retract at that point. Interesting. It is clear fact that the laws applies only when the mark is made in the presence of the seller, or if the seller says, mark your purchase. For this indicates that he has agreed to the transfer ownership as explained with regard to the chazaka and meshicha. Okay, so that's important, right? When a person agrees to a transaction with a verbal commitment alone, it is appropriate for him to keep his word, even though he did not take any money at all, did not make a mark on the article he desired to purchase, nor leave security. If either the seller or the purchaser retracts, although they are not liable to receive adjuration mishapara, because nothing happened over here, it's just a word, right? There was no mark, right? There was no, cutting up the meat and putting it, packaging it, and that's for you, which of course is a mark, right? No transaction here, and so therefore there would be no mishapara. But yet you gave your word, you should keep it. They are considered to be faithless, and the spirit of the sages does not derive satisfaction from them. So not a good thing to do. Similarly, if a person promised to give a colleague a gift and failed to do so, he is considered to be faithless. When does the above apply? With regard to a small gift, because the recipient will depend on a promise that he was given. With regard to a large gift, by contrast, the giver is not considered to be faithless if he retracts because the recipient did not believe that he will give him this article until he transfers ownership through a formal kinyan. Wow. Right. So, if you just promised to give, I don't know, some flowers and you didn't bring the flowers, he was expecting the flowers, I don't know, right? But if it was, a car you're gifting, well, you didn't kind of expect it until some kind of formal transfer of ownership.
It's like giving an oath or making an oath or promise or oath or vow.
It's not oath or vow, it's your word, right? You made a promise. So could
you simply name it instead of
yeah, but the point over here is someone else is expecting something. That's the point over here. Right now, here we're going from your word in business, right? That you won't get a mishapara, but it's faithless. Now we're going in that you promised something to someone, also being faithless, if they expect it. That's the nuance over here, right? If they didn't expect it, and that's why it's a small gift that you were giving, right? You promised us flowers, a small gift. If you promised a guy a car, so not there isn't an expectation until there's some formal kind of acquisition that will be made, right? So in other words, just my words wouldn't be sufficient because it's a large gift. So I would expect some more greater formality of acquiring the car as opposed to, a bouquet of roses. Amazing. Following rules apply when a person gave money to a colleague to purchase landed property or movable property, and the agent left the colleague's money in his domain and went to purchase the object for himself with his own money. So again, about faithfulness, right? The purchase he is performing concluded, he is, however, considered to be a man of deceit. He went and bought it for himself with his own money. It's true, it's with his own money. So he's not a thief, but that's deceitful. I gave you a good, I gave you good property to buy, but I told you about it to buy for me, and you went and bought that property for yourself. And the purchase is a purchase, right? But this person is deceitful. If an agent knows that the seller has affection for him and honors him and would sell the article to him, but not to a person who charged him with purchasing it, the agent is permitted to buy it for himself. He must, however, return and notify the one who sent him. If he is afraid that the other person will come and purchase the article before him, he may purchase the article for himself and then notify the one who sent him, only because there is an affection between them. Several rabbinic authorities have ruled that if an agent purchased an article for himself using the money entrusted by his colleague, after considering it to be a loan, he is considered to have purchased the article for himself. He accepted this claim. I considered the money that was given to me to be a loan, right? Money, because when money is given, it's given to be used, and therefore, you can't say, "Oh, this money." I differ and maintain the ruling is not true. Instead, the purchase belongs to the principal, as will be explained with regard to the laws of investment partnership. Okay, we'll get to that later. Okay, the following rules apply. When 3 people give money to one agent to purchase an article for them, if the monies were mixed together, right, so it's not one person, so therefore that money belongs to this one guy, right? As we just learned previously. Huh?
The money is given
to one agent, but the monies are mixed together, right? The agent used only a portion of the money to purchase the article. The article consists of property of all purchasers, and they divide ownership of it according to the share of the money. This applies even if the intent of the agent was that the article be purchased by only one of them. So let's say he was given $500 in the end, but he was given 300 and he was given 300 by one, 100 by another, and 100 by another. So the one who gets 300 will get, will get 3/5, and the other ones will get each 1/5, and whatever is given back is right. Halach number 14. If the money of one of the partners was bound up and sealed, and that money was used to complete the purchase, the partner whose funds were used alone acquires ownership. This applies even if the agent intended the article to be acquired by all the partnership as a joint enterprise. So interesting. So in other words, he got a wallet full of money from one of the guys, right? And it's bound up and sealed. And that's only for one of the partners. And he gave only that money to purchase the property or the goods. The partner whose funds was used alone acquires the ownership. Now, obviously, if he wants to retain partnership with the others, he can do that. But we're talking about a legality over here because it was only his money that was used for the purchase. Right. So therefore, it only belongs to that one partner. Right?
The funds came from this individual alone.
Yeah.
No one else.
Even if the agent intended to do it as a partnership, as a joint enterprise. That's a very interesting halacha. All right, managed to do the entire Baruch Hashem. All right, that's fascinating stuff. All right, let's get down to business.